Welcome back to this series of web-based presentations on procurement basics. The series is sponsored by the Commercial Law Development Program of the United States Department of Commerce. This particular presentation provides an introduction to the World Trade Organization's Agreement on Government Procurement, what I will call the GPA. And for your background, my name is Robert Anderson. I am honorary professor in the School of Law at the University of Nottingham in the United Kingdom. And I'm also a former staff member of the World Trade Organization in Geneva, Switzerland, where I was in charge of this area of government procurement within the WTO Secretariat. With respect to the contents of this presentation, I will first explain the objectives and the main elements of the WTO Agreement on Government Procurement. Secondly, I will outline the renegotiation of the agreement, which culminated in 2012, and which has really made the agreement simpler, easier to implement, and more relevant to today's procurement problems and issues. Thirdly, I will discuss the growing membership and the evolving global reach of the GPA. And I'll close with a few words on the policy significance of the GPA in today's global economy. Before going further, I'll just mention some sources that will be useful to any of you who are watching this who want to kind of dig further into the details of the GPA. And firstly, I would recommend that you take a look at the WTO Gateway page on government procurement. I've shown the link there on this page. But it's easy just to log on to the WTO website and then look for the entry on government procurement under trade topics, and then you'll be there as well. So that the procurement gateway page provides lots of useful information, including the text of the agreement itself, including the detailed market access schedules, which are there for each of the participating member governments, and other useful historical and other information. Underneath the WTO website, I've listed 3 of my own publications in this area. These provide additional background on, the current economic impact, the significance of increases in the GPA's membership, and other related points. So I'll now discuss the legal nature of the GPA, its objectives, and the status of the GPA within the overall WTO system. The first point I'll mention is that the GPA is an international treaty. It is a part of international law, and therefore it is actually binding on the participating WTO member governments, what we call the parties to the agreement, when they accede to it. No one can force anyone to join. The individual GPA parties must seek accession to the agreement and be approved for participation by the other GPA member governments. So, what are the objectives of the agreement? I would mention 3 key objectives. The first is to ensure access to the other GPA parties' procurement markets by the goods, services, and suppliers of all GPA parties. This is central to the role of the agreement. A second very important objective is to promote the efficient and effective management of public resources. And in practice, that means good value for money in each participating member government's procurements. And the third objective I'll mention is to promote reforms and good governance in the government procurement sector. And specifically, when we speak of good governance, we mean transparency, fair competition, and very much an absence of corruption in GPA-covered procurement activities. Lastly, for any of you who may be wondering how the GPA fits within the overall WTO system, I will explain that this is what we call a plurilateral agreement within the WTO. This means that not all WTO members participate in the agreement. As I've mentioned, a government needs to seek accession to the GPA and must be approved by the other participating governments before it can come in. Nonetheless, the GPA is very much a part of the WTO system. It is listed in what we call Annex 4 of the Marrakesh Agreement, which is the founding document of the WTO itself. Membership of the GPA is increasing significantly over time, and the agreement is kind of a success story within the WTO, and it's definitely of increasing interest as a tool of economic integration and reform. I'll now discuss what I refer to as the 5 main elements of the GPA. This is just an easy way to understand the basics of the agreement. And of course, I hope that some of you eventually will want to look at the text of the agreement for yourself. But until then, this is a good entry into the essence of the agreement. So the first main element that I will mention is the rules on what we call national treatment and non-discrimination with respect to participation in each party's covered government procurements. These rules certainly are a cornerstone of the agreement. They are intended to ensure that each participating country or WTO member in its own procurement system and legislation treats the goods, services, and the suppliers of all the GPA's parties, gives them treatment which is no less favorable than the individual parties give to their own goods, services, and suppliers. The second main element that I'll mention concerns what we call the coverage of the GPA. And here, I need to explain that the GPA, the Government Procurement Agreement, does not automatically apply to all of a participating WTO member's procurements. Rather, it only applies to what we call GPA covered government procurements. That's the term of art, covered. And how do we know which government procurements are covered? Well, we know that from some rules within the GPA text itself, but we know it mainly from what are called the market access schedules of the GPA parties. The formal name for these is the Appendix 1 annexes. These are attached to the agreement. They are legally a part of the agreement, and they specify for each individual GPA party, they specify things like the ministries that are covered under the agreement by that country, the other government entities, perhaps state-owned enterprises or public utilities that are covered by that participating government. They also specify thresholds. This is a very important element. The GPA only applies to procurements which have higher value than listed minimum threshold values, which are specified in the schedules. The GPA schedules also specify which goods, which services are covered by the agreement with respect to that party. They specify covered construction services, and they also list specific exclusions. So really, a lot of the details of application of the agreement are covered in these GPA schedules. This is a very important part of the agreement in practice. The third main element that I'll mention here, main element of the GPA, consists in the procedural rules of the agreement. These are intended to better ensure transparency and open competition, non-discriminatory competition. And these rules deal with matters such as tendering procedures, qualification of suppliers, time limits, documentation, opening of tenders, contract award procedures, and so forth. And I would just like to mention here that all of these procedural rules are based on best practices internationally as they are understood by the participating WTO member governments. So these procedural rules also, are kind of potentially provide a template for pro-competitive market reforms. So we've now covered 3 of the 5 main elements of the GPA. Just for review, I'll remind you, the first main element was the general rules on non-discrimination and national treatment. The second main element was the market access schedules of the GPA, which determine which specific procurements are governed by the agreement. And number 3, the agreement's procedural rules. So, coming now to the fourth main element, this concerns the enforcement mechanisms that are available under the agreement, under the GPA. Remember, I said that the GPA is a treaty, it's part of international law, so it stands to reason that it will have enforcement mechanisms contained within it. And there are 2 such mechanisms that we need to mention. The first is actually the formal WTO dispute settlement system. This is a state-to-state system. It's a little bit slow to get going, but it's there, and it's an important part of the WTO system as a whole, and put in place by members to resolve specific disputes between particular member governments of the WTO. And the WTO dispute settlement system is available to resolve disputes under the GPA. Nonetheless, the second enforcement mechanism is much more widely used in practice. That is the domestic review procedures that must be put in place by each participating member government. These domestic review procedures, that's the WTO term for them. In the US, they're often called bid protest systems. In the European Union and some other countries, they're referred to as remedy systems. The basic idea here is that each member government that participates in the GPA must have in place an independent complaint office of some kind, to which suppliers that feel they have been wrongly treated in a particular procurement process can go and make a complaint and expect to have that complaint reviewed impartially. This is a very important part of the agreement, and what we find in practice is that the domestic review systems work so well that relatively little use is made of the formal WTO dispute settlement system with respect to disputes under the Government Procurement Agreement. It's just not necessary because most disputes are satisfactorily resolved at the level of domestic review systems. Okay, and the last of my 5 main elements of the GPA is the built-in mandate for future negotiations under the agreement. This is an amazing part of the GPA. In effect, it ensures that it is self-renewing and continues to evolve over time, because the GPA contains a specific mandate requiring the GPA parties eventually to undertake further negotiations to improve and update the agreement and to broaden its coverage. And so this helps to ensure that the agreement does not become a rigid instrument out of touch with the realities of procurement practice, and instead it evolves over time. It's a kind of cooperative, collective, continuing work in progress. So I'll now speak about the renegotiation of the GPA, which culminated in 2012. This was a significant development for the agreement and for the parties. The revised agreement was concluded in 2012, came into effect in 2014, and by January 2021, all of the existing parties will have migrated to the new GPA text. It takes that kind of time because this is a formal international law process. Each participating party must accept the revised version of the agreement before it fully takes effect. So, and there were three main elements to the renegotiation. The first was that the GPA text was overhauled and modernized. The second element was that additional market access commitments were added to the coverage of the agreement. Specifically, about $100 billion annually of additional procurements were covered by the agreement, bringing the total coverage of the agreement by all the parties collectively to around $1.7 trillion. It's a pretty significant coverage. And the third element of the renegotiation involved a commitment by the parties to take up several new work programs dealing with issues such as small and medium-sized enterprises, sustainability, also statistics, and gaps in coverage in the coverage of the agreement. So these were kind of homework projects. They were intended both to improve, facilitate the improvement of the administration of the new version of the agreement, and also eventually to contribute to a further renegotiation of the agreement, which has not yet started, but as I mentioned, is called for in the text of the agreement and will eventually take place. We don't know when. We'll now mention a bit more about the revisions that were made to the GPA text as part of this overall renegotiation. And the first point to make is that the core principles of the revised text are the same as the older version. These are, as I've mentioned, non-discrimination, transparency, and procedural fairness. However, the revised text nonetheless contains several distinct improvements. Firstly, there was a complete revision, of the wording of the agreement with a view to making it more streamlined, easier to understand, more user-friendly, easier to implement by new parties to the agreement, and so forth. Secondly, the GPA text was updated to take into account important developments in government procurement practice amongst the parties. Notably, the greatly increased use of electronic tools as part of the procurement process. So this was a really important development that is a very central to modern procurement practice, but was not reflected in the old 1994 version of the agreement, which was put in place before kind of this trend to the use of electronic tools took off. And so the third highlight I would mention is that additional flexibility was introduced into the GPA for parties' procurement authorities, just making it easier for them to implement and follow the agreement. For example, there are now shorter mandatory minimum notice periods when electronic procurement tools are used. There's also shorter minimum time periods when governments are procuring goods and services of types that are available on a routinely on a commercial marketplace. So the fourth highlight of the revised GPA text that I would like to mention is that the GPA's significance for good governance and the fight against corruption is now much more explicitly recognized in the text of the agreement. It's recognized in new substantive provisions that require participating governments to carry out their GPA-covered procurements in ways that avoid conflicts of interest and prevent corrupt practices. And these new substantive provisions are backed up and reinforced by new language in the preamble to the agreement, which specifically refers to the United Nations Convention Against Corruption and manifests the importance that the parties attach to the GPA as an instrument of good governance. And the fifth and last highlight of the revised text that I would like to mention is the revised and improved transitional measures, or what is called in the WTO sometimes special and differential treatment for developing countries that accede to the agreement. Very significantly, under the revised provisions, these improved transitional measures are not sort of automatically given away. They have to be negotiated and agreed to at the time that a new party is admitted to join the agreement. And such measures are intended to be tailored to the particular needs of the individual accession candidates, and also to be phased out over time. That's important too. I'll now speak of what I call the growing global reach of the GPA. And what is most interesting here is that the GPA is in the process of transforming itself from what initially, let's say back in 1994, was kind of a club of developed countries in Europe and North America, into a much more genuinely multilateral instrument, which will include not only those developed countries, but also a growing number of developing, or what you might call transition economies. So at the moment, it's 48 WTO members that are covered, that are legally bound by this agreement. That includes the EU and all of its member states. Also includes the US, Australia, Canada, Japan, New Zealand, Norway, and Switzerland. But already we have a number of countries that came in more recently and or represent different parts of the world. Those include Aruba, Armenia, Hong Kong, Israel, Korea, Moldova, Montenegro, Ukraine, Singapore, and Chinese Taipei. And in terms of further developments, Well, it's interesting. The UK is set to become a GPA party in its own right early in 2021. Until now, it has been covered through the EU schedules because, of course, it was a member of the EU for a long time. Now, and so that's an important development, and it's certainly the UK made it very clear that it wanted to remain in the GPA, and that's been approved. So then additionally, we have 11 other WTO member governments that have initiated their accessions to the GPA. Well, you see the list there: Albania, Brazil, China, China, very big and significant, Georgia, Jordan, Kazakhstan, the Kyrgyz Republic, Oman, the Russian Federation, Tajikistan, Republic of North Macedonia. Again, these are all countries that, well, Brazil and China are huge developing countries. And the others as well are, from different parts of the world than the original participating member governments. So we also have, in addition to that, there are 4 additional WTO members that have commitments to seek accession as part of their WTO accession protocols. These are Afghanistan, Mongolia, Saudi Arabia, the Seychelles, so you see that this process of broadening the membership is continuing. And it's worth noting also that there are 36 observer governments that follow the GPA. Observers are not, they don't have any obligations under the GPA. They're not legally bound by it, but they're just following it, indicating at least they want to learn a bit and be aware of new developments in the agreement. So all these developments, I find them very interesting. As I say, this agreement, which started out as a club of European and North American countries, is now gradually, slowly becoming a truly multilateral instrument. So let me now mention some other developments which are extending the reach and significance of the GPA around the world. The first is that the GPA, the WTO Agreement on Government Procurement, has become the model for chapters on government procurement that are increasingly included in regional and bilateral trade agreements worldwide. These include many of the European Union's regional agreements. They also include the recently negotiated Comprehensive and Progressive Trans-Pacific Partnership Agreement. So we see that, in many cases, countries which are not literally parties to the GPA itself, but they have adopted increasingly the GPA's standards through the action of through their participation in these regional trade agreements. I can also mention the GPA increasingly is used as a benchmark for national procurement reforms. This is necessary really because all GPA members must have GPA compliant legislation. The GPA is also carefully harmonized with what is called the UNCITRAL Model Law on Public Procurement. UNCITRAL is the United Nations Convention on International Trade Law. So this is a significant thing. And the GPA also is referenced in the World Bank's new procurement guidelines as well. So I'd like to conclude this presentation on the GPA with a couple of slides that emphasize its policy significance in today's global economy. The first point I'll make is to remind everyone of the huge economic, social, and developmental significance of government procurement. Government procurement is a huge proportion of economic activity, something like 13 to 18% of GDP on average worldwide. And it also has tremendous social and developmental significance. What I mean by that is that, when we think of what governments purchase through their procurement systems, it can include medicines for distribution in hospitals and other health systems. It can include the construction of universities. It does include very much public infrastructure projects, which can be vital to ensure that our infrastructure systems function effectively. We're speaking of airports, port facilities, roads, highways, energy projects in many cases. All of these things are terrifically important for development and for growth. Another interesting point is that a government is often the single biggest customer for individual suppliers, especially in the services sector. So this is something which adds to the strategic importance of government procurement and draws particular interest in government procurement on the part of these companies. So, and a third point, which is really also the philosophy of the GPA, and that is that it concerns the importance of transparency, effective competition, and unrestricted supply possibilities to achieve best value for money in national infrastructure projects, in other government procurements, and I would say to promote development generally. Beyond this, I would say in the last decade in particular, we've come to see the importance of open and transparent government procurement markets for the prevention of corrupt practices and supplier collusion. And in that context, the GPA and participation in the GPA has come to be seen as a catalyst for necessary internal reforms in some countries. And that's, to me, is a very interesting development. In other words, what I'm saying is that countries are joining the GPA not only for reasons of ensuring market access, but also, as a tool for improving governance within their own procurement and having better results in their own government procurement systems. Now, and as my concluding point, I would like to say that regardless of whether you join the GPA or not, domestic capacity building, institutions, leadership, and supplier engagement will always be crucial to success in this area. So that concludes this presentation. I hope it's been interesting for you. I encourage you to consider learning more about this agreement, and I wish you success in all of your endeavors.